basis for rights to privacy in the private sector is largely, as I said, based on some statutory claims. Um, um, there are states that are trying to enact legislation, and the federal government, that mirrors the federal law regarding the compilation and dissemination of information. There is recognition of a constitutional right to privacy under state constitutions that may necessarily extend to private sector employees. It depends on state by state which ones protect, which ones don't. We are protecting employees only in certain areas of employment. Um, so, with respect to their personnel records or the use of credit information, we know this from the Fair Credit Reporting Act, et cetera. Federal laws and the Constitution affording protection only to federal employees and those subject to state action. There are, again, the Constitution only supports federal employees and those, doing business with state action. Where we see additional basis for right to privacy in the private sector is tort laws or common law, where there are civil wrongs against an individual, and there's usually um, privacy protections in terms of intrusion into seclusion, the publication of private information, the publication that places another in a false light, and defamation. So when we are misrepresenting information about somebody, or we are publicly defaming or slandering somebody or libeling them, those are particular important issues. So we have to be incredibly careful in the language that we use when we're talking about individuals, particularly in public situations. And one of the cases in the textbook I know addresses the fact that someone thought that they were being, I believe slandered was the appropriate term, but fundamentally, when the company was sharing information about, some violations of their of information on their part, they didn't reveal names, so there was no public defamation of anybody involved in that. When we share information that puts somebody in a false light that's not verifiable, that also is problematic. Publication of private information. Again, we can't publicize someone's private info. For example, someone tells you that they are transgender. They want to keep that private. We cannot share that information publicly because that is considered private. And people have a right to be secluded, to have some private space around them. So again, intrusion into seclusion is key. So Exhibit 14.5 talks about the tort of intrusion into seclusion. In order to make your prima facie case for this tort, the defendant employer intentionally intruded into a private area. The plaintiff was entitled to privacy in that area, and the intrusion would be objectionable to a person of reasonable sensitivity. For example, intruding into an employee's personal phone records, or intruding into a changing room where there is a reasonable expectation for privacy and that it was sensitive because they did not protect the privacy of those individuals. In terms of the right to privacy in the private sector, we also have the disclosure of private facts. For example, a prima facie case is made when there was intentional or negligent public disclosure of private information and private matters, and the disclosure is objectionable to a reasonable person of ordinary sensitivities. So the Schoen versus Best Formed Plastics case is a good example of that. So when you are making a public disclosure of someone's information, particularly around things like LGBTQ, that's a very common area where we see that being addressed, where someone has has private information that they don't want shared with the public or with others in their workplace, and that information is shared, or someone's looking for a reference, that information might be shared across from one organization to another in terms of doing a reference. And so we protect private information when it's given to us, and without doing that, we create major problems. In terms of publication in a false light, making our prima facie case, we have to argue that there's a public disclosure of facts, that those facts place the plaintiff in a false light before the public. It's in a manner that's highly offensive to any reasonable individual, that the publisher has knowledge of or recklessly discarded the false light of the publication, that it requires a broad publication. It's not just a one-on-one with somebody, but a broad publication such as in a annual report or in a press release or information like that. A protection may be waived by the plaintiff's own actions or publication of similar facts. So if the plaintiff makes the information public, they cannot then go back to the employer and say, you can't make it public, but I can, because once you've made it public, they're no longer protected under false light. In terms of making a case for defamation, the prima facie case is as follows: that there is false or defamatory words concerning the employee, that they were negligently or intentionally communicated to a third party without their consent, and the resulting harm to the employee was that they were defamed. So libel is defamation when it's in writing, so in a letter, libel, and slander is in an oral statement. So if you verbally share with somebody some private information that they would be, and particularly if it's inappropriate or untrue, then it would be considered defamation. In terms of regulating employees' off-work activities, private activities can be regulated if their off-work conduct can affect their performance on the job. And the argument around tobacco, for example, how it worked for Waco was that he believed that those who were smoking tobacco were more likely to be sick, increasing healthcare costs. They were more likely to be absent, creating productivity issues. They were more likely to take more breaks in the use of tobacco. There are some states that do limit and sort of protect tobacco so that you cannot use tobacco as a basis for that because it's a legal product, right? But the Affordable Care Act for insurance, also known as Obamacare, permits tobacco surcharges on healthcare premiums up to 50% more. So some states, go to the maximum 50%. Some allow less. But the ACA does allow for that surcharge, largely because it does cost more, and you can pass those costs on to those employees because of the fact that they smoke. In terms of weight and wellness, there is a big issue with how that interplays with the idea of disability. And with weight and wellness, how do we define what is well? We know that BMI, body mass index, is arbitrary, and a high BMI doesn't necessarily mean someone's unhealthy. There can be people that are considered high BMI that might be in wonderful shape, that exercise regularly. Everybody's body build and structure is very different. There are people who have very slight body builds that a BMI of 20 might be too much for them, and there are people with more hefty body builds, like myself, for example, that might be considered, morbidly obese, and hence would be considered a concern under BMI. So weight and wellness is really iffy. So be careful about that. The attitudes on the workplace dating have a huge impact on issues of privacy. Um, for example, McCavitt and Swiss Reinsurance American Corporation said dating is not recreation under a New York statute, so that can be considered issues of privacy related to that. So we want to be careful about making sure we understand our state statutes and our state laws around workplace dating or around what we can and can't constrain people to do. In terms of workplace dating, there are a lot of employers that have made statements about ensuring that if you are related to each other, you can't work in the same department. There are some companies that say if you're related to each other, you can't even work in the same organization. And then there are other companies that have no issues with this. And I think when we have financial services businesses, when there's a high probability of embezzlement and things like that, then we are less likely to allow people in the same department to be working together. So those are some of those concerns. So marijuana still remains a Schedule One substance, a Schedule One's controlled substance. So we've talked a little bit about marijuana use with respect to Americans with Disabilities Act and whether or not marijuana use is protected under the ADA for people who are experiencing nausea and other pain management techniques. And as we can say, it's mixed at best, right? There are a lot of states, though, that have made it legal for medical use as well as legal for recreational use. Illinois, one of them. Marijuana is only legal for medicinal reasons in Missouri. Of course, we all know that doesn't stop anybody from using it for, recreational reasons, but nonetheless, having the statute on the books that makes it legal to purchase it and use it in your state certainly protects you at least from local issues, right? And of that nature. The big concern, of course, is how do we develop testing that tells us whether or not somebody's impaired if they've used marijuana? For example, with alcohol, your body processes alcohol at a fairly rapid pace, and we can monitor people's inebriation levels based on how they do on a breathalyzer or a blood test. So we know when there's alcohol in their system that they may still be impaired, and when they're not impaired. Alternatively, we don't have that level of sensitivity in our tests for marijuana use. It's simply, is there marijuana in their system? Yes. At what level is it considered an impairment? At what level is it not considered an impairment? So these are concerns that we have in terms of our testing and making sure that we have that addressed. There are a wide variety of companies and geographic areas that have a wide range of acceptance or rejection of marijuana use. So we do need to figure out how to have more consistent policies, I think, personally, at the federal level. And right now, as long as it's still considered Schedule One controlled, it will remain illegal at the federal level. We do need to figure out whether or not it makes sense for us from a cost-benefit analysis, from a legal and HR implication level about whether or not we should continue to monitor marijuana use. Certainly, we don't want people high on the job, but what somebody might do, at night, right, or during the weekends, if it's not going to affect their ability to do their job, how much do we want to control that? And right now, the employer has the right to make those control decisions, but hopefully we can get better testing and a more fine-tuned assessment of when someone is impaired and when someone is not impaired. There are some additional considerations you'll see on Exhibit 14.8 regarding activities in political campaigns and political speech and what is protected and what is not. I know for me, as a state of Illinois employee, I cannot use my state of Illinois resources to actively stump for a political candidate, and I cannot use my position as an employee of the state of Illinois to advocate for one political candidate over another. I'm not allowed to use that platform to do that, but that doesn't mean that I can't do it in my own private life and in my own private use of my own emails. So these are some of the concerns to think about. Natural hairstyles is also an important issue, whether or not a natural hairstyle is okay. For example, someone who uses locks or someone who may choose to not, straighten their hair and curly hair is a concern as well too. Whether or not a fro would be considered appropriate. And there's a very white supremacist perspective when it comes to how we think about hairstyles. Now, it's one thing if locks or fros or things like that would be considered unsafe for work, if there's a safety consideration involved. That's a very different situation than someone who's simply wearing locks or a fro and we don't think that it's professional. Well, that's a very white-centric perspective, and we have to respect that different groups have different styles of hair, and as long as it's neat and orderly, then we should be careful about the assumptions that we make about what is to be considered an appropriate hairstyle or not. Now, I work for the state of Illinois. I work in higher education. If I have blue hair, my employer doesn't care. And there are often times when I do dye and highlight my hair with blue or purple or red or fun colors because I can. And that's not the case necessarily for others. And certainly, other employers might say blue hair is not considered professional. And as we know, they have the right to decide that. In terms of other lifestyle restrictions, really it comes down to at will. If an employer says this is not okay, you can't dress a certain way unless it's protected with religious garb, um, at will basically leaves employees with very little protection. An employer can make the determination about whether or not they believe a certain style of clothing and things like that are protected or are inappropriate in the workplace.